From the Library of Congress in Washington, D.C.
All right, thank you everyone. This is our next panel for the Section 1201 rulemaking. This is Class 9 Software Programs Software Preservation, or Computer Programs Software Preservation. And I think, again, I see a lot of people who have participated in the past. If you would like to speak to a question, tip your placard up and we'll call on you. Try to keep your remarks snappy because we have been having an issue of running a little bit longer. It's helpful to try to foment discussion that builds upon the written comments as opposed to reiterating them. And to the extent you can kind of engage with what each other are saying. I know it's a little bit difficult in this panel format, but we have found that to be the most useful. So my name is Reagan Smith. I'm Deputy General Counsel at the Copyright Office, and I think we'll introduce ourselves on this side, and then you can on that side, and then we'll just dive right in. Thank you.
Julie Saltman, Assistant General Counsel at the Copyright Office.
Kevin Amer, Senior Counsel in the Office of Policy and International Affairs, the Copyright Office.
Anna Chevet, Assistant General Counsel at the Copyright Office.
John Riley, Attorney Advisor, Copyright Office.
Stacy Cheney, Senior Attorney Advisor at NTIA, National Telecommunications and Information Administration.
Mr. Lowood, if you would like to introduce yourself and any affiliation you may have.
My name is Henry Lowood. I'm the Curator for History of Science and Technology Collections and Film and Media Collections at Stanford University in California.
Jay Freeman, SORC IT.
Jessica Meyerson, Educopia Institute and Software Preservation Network.
Kendra Albert, I'm a Clinical Instructional Fellow at the Cyber Law Clinic at Harvard, and I'm here representing the Software Preservation Network.
Jonathan Ban for the Library Copyright Alliance.
Jonathan Zook, the Innovators Network Foundation, speaking on behalf of ACT, the App Association.
My name is Lindsay Molds, and I am the Software Curator at Rhizome.
Matt Williams from Mitchell, Silberberg, and NUP. I'm here for AAP, ESA, MPAA, and RIAA.
Chris Moore, Software and Information Industry Association.
Christian Troncoso with BSA, the Software Alliance.
David Taylor, Counsel to DVD, CCA, and AACSLA.
Okay.
Good afternoon again. So I think to start things off, I'd like to ask the proponents in particular if you could provide some sort of a high-level overview of the, touching on the various types of circumvention and preservation activities you would like to engage in. You provided obviously a lot of examples in your papers, but I think it would be helpful for us just to get sort of a high-level overview of some of the need for circumvention and the types of activities that you're prevented from doing as a result of access controls. Ms. Meyerson.
Yes, hi. So as representative of the Software Preservation Network, I can sort of provide a more general comment at scale. So we have about 81 institutions represented within the Software Preservation Network. These are all libraries, archives, museums, or institutions of that are focused on cultural heritage preservation. And within that group, that began back in 2016. There was a survey that we completed as part of a grant project, which led to a forum, an open call, and that resulted in a community roadmap. And the sort of like legal barriers surrounding software preservation, which is closely coupled, preservation and access being closely coupled, all of those institutions agree that that's one of the leading barriers, that the technical barriers for doing some of this work are less of an issue, but this is still a major challenge that we all face in order to fulfill our professional mission of preservation and access of the cultural record.
Thank you. Mr. Lowood, I would just ask, so specifically, as I understand it, we're primarily talking about software that is no longer commercially available, correct? And if you could talk about sort of the types of TPMs that are involved. I understood from your papers that in many cases they involve hardware checks, where something was on an obsolete format, but it might not be limited to that in all cases. So if you could elaborate.
Well, the two, I guess, main categories of work that we find are blocked by TPM are our efforts to migrate software from older media to more robust forms of media that we feel will work in a preservation environment. That's one thing, and of course another is research access to those disk images that we might create, and that often require the researcher then will then involve the researcher in counting some form of TPM when they try to access those disk images that we've saved. Now, the kinds of things that we'll encounter in situations like that, hardware blocks are one sort of thing, copy protection mechanisms would be another. There were also certain platforms like the Amiga that had specific mechanisms that could be used in different ways by software publishers that would affect our ability then to remove data from the data formats that we have in our collection. Those are just a few examples of the kinds of things that we encounter.
Mix Albert?
Sure. So I think I just want to expand upon what Mr. Lowood said and just note, I don't want to repeat our papers, but we do lay out a number of specific technological protection mechanisms. And one thing that's become clear, often when you're preserving a collection of software, it doesn't get sorted by TPM when it comes in. Often any or all of the different technological protection mechanisms laid out in the original papers can apply to specific forms of software. So anything from product keys to bad sector copy protection or other sort of like physical ways of reading a disk to hardware checks. All of those are potential options for different sort of software produced in different periods.
Do you think that we're in agreement that if the format, if the operating system or the hardware is obsolete, that itself is not a TPM? That's what the office said in 2006, and I want to make sure we sort of have a base layer of that not being in contention now.
I'm sorry, I'm a little confused. So which in 2006?
So in 2006, we said that formats that require obsolete operating systems or obsolete hardware as a condition of access, that exemption was not, that part of that exemption in 2006 was not recommended because the Copyright Office concluded there were no access controls implicated and therefore no exemption was needed. So it was, go at it for preservation purposes, but there was no circumvention, and so 1201 is not implicated.
I wasn't aware. I don't know if you want to, Mr. Band, I don't know if you want to chime in.
I guess actually Ms. Mold has been waiting for a while, so if you don't want to speak to that, that's okay, but.
I didn't want to speak to that specific point that you just brought up, but I did want to just introduce what Rhizome and what a lot of other cultural institutions, and particularly museums, struggle with at this point, is that when we have digital art pieces or other interactive media that is given to us, on indefinite loan, or we have the full rights from an artist to display it, a lot of times that we find that there is sort of obsolete support media that's needed, or there are software dependencies that are no longer commercially available, or that we have licenses to but can no longer legally activate based on TPM. And so that's sort of the specific problem that we face as institutions who are working with digital artifacts, is that even if we have the base software itself, we have these dependencies where we can't circumvent the DRM in order to support the software.
Right. Mr. Troncoso, do you want to answer the question? I think what Ms. Mold, you listed three things, and the first one I wasn't actually sure if a technological protection measure was implicated. I think that's part of what I'm trying to sort out in terms of what the ground we're trying to cover here in this potential exemption.
So I think that you've put your finger on something that I think I realized earlier today as I was looking back at the docket and the submission so far. I want to start out by saying with software preservation networks, narrowing of the class to works that are no longer commercially available, we're completely comfortable with the activity that they're seeking to engage in. And so I think from our perspective, I can't speak for the other witnesses, we would be comfortable with an exemption that covers that. However, I do wonder whether what's at issue has more to do with obsolete TPMs than what sort of how this has been framed so far. And then it gets to your question about whether an outdated operating system itself can be, is a TPM. But I think that's where I think the issue is. I guess what I don't understand fully is why an exemption that allows for circumvention of obsolete TPMs on computer programs, whether that would get the proponents all the way to sort of what they need in order to cover the activity that they're interested in doing.
This seems somewhat definitional of what is an obsolete TPM or what is a TPM that might itself be working. It's not like a broken dongle or something like that, but the format.
Yeah, so the question is if they have a lawfully acquired copy of software, unless the TPM is no longer working, it's also a bit unclear to me what is prevents the preservation activity. I feel like I'm losing you on that.
Maybe elaborate. Yeah.
What's that?
Yeah.
So if they have a lawfully acquired copy of software and the TPM is functioning as usual, the only thing that could really be a hindrance to the preservation activity is, I think, if the operating system is outdated or if the sort of computer programs that they're seeking to access in a new sort of that they're porting over from either old media or if it was, I guess I'm struggling to understand what exactly the activity is that they need the specific exemption for.
Well, I think they've given some examples, right, where there's like a date and the date is in the past, and so it is hard to access something, or maybe the server check doesn't work anymore. So
wouldn't that be an example then of an obsolete technological protection measure it's no longer functioning as?
I don't know if a date based TPM would be no longer functioning. It's just the problem is we're now in the future, as it were, right?
Okay.
I don't know, but.
Again, like I said, all of the activity that they're seeking to engage in on out of works that are no longer, computer programs that are no longer commercially available, we're pretty comfortable with it. And from my perspective, it's about just right-sizing the rules so that it's, contained to that activity.
So here's how I understood it from your papers, and obviously you can, it's probably wildly oversimplified, but I mean, as I understood it, you have cases where you have a program on a floppy disk, for example. You need to, for preservation purposes, you need to migrate it over to a modern system. But in order to open the program, there might be a hardware check that requires the original floppy disk, which is not being used anymore because you've migrated it over. Or is that? Or you might have a server check after in which the server authentication has been discontinued. Are there other kind of paradigm examples of the types of things you're trying to do?
Well, I'm not a technologist, so I can't speak to paradigms, and hopefully other people here can. But I think one way to look at it is, to some extent, the software industry is a history of failures, right? You have so many companies that have been trying to do different things over the past 30, 40 years. Some of them are successful and they end up becoming members of BSA. But the vast majority aren't. And they have, and the number of companies doing it's just a vast ocean of software with all kinds of technological protection measures. Some of them may have been developed by that company for itself. Some of that might have been standard at the time, but are no longer available. Some of that might be something that is some kind of technological protection that is still available from someone, but again, but it's not available to the library that's trying to preserve it. And so that's why it's important to try to come up with an exemption that is as broad as possible to address all of these circumstances. I certainly agree that simply by virtue of the fact that the operating system is obsolete and not commercially available, I mean, that by itself is not a TPM, but that's not what we're worried about. We're worried about sort of, all of these myriad possibilities that people do encounter. And again, there's so much software out there that for companies that are long out of business, but have all kinds of important value that it's, that's important for people to be able to access and learn from and sort of avoid, reinventing the wheel over and over again, as well as all kinds of other works that are dependent on, whether it's, architectural, blueprints or artistic works or so forth. And so, we just need to make sure that that isn't getting lost. And, the longer we wait, the more we'll get lost because the more is getting created. And so, again, the plea is to have the exemption as broad as possible, as user-friendly as possible, because, again, the goal is to get to this, the non-commercially available material in a way that, certainly won't hurt any of the existing companies that are succeeding in the marketplace now.
Thank you. So if you all could, provide any additional detail about, Mr. Troncoso's question and sort of the process, and then I'm going to come back to the opponents to ask, because you, Mr. Troncoso, indicated that there is some level of agreement here, I think, but I want to make sure that there isn't, at least with respect to the notion that we're not talking about currently commercially available software, but I want to make sure that we highlight any points of difference in terms of how that's defined. I think Mr. Freeman was next.
So I think there's some subtlety involved with the that question about operating systems and outdated and computers and operating systems. So when a museum is trying to preserve a work, it essentially is going to have to preserve the entire apparatus of the work in a way. It's not sufficient to just know that the information is theoretically there. It has to be something that you can see, you can execute. I have a friend who does interactive digital art, who one of his pieces was recently acquired by the San Francisco Museum of Modern Art. And it's something that was designed to run on an iPad. And the scenario there is that if you upgrade the software on that iPad to a newer version of the operating system, it is going to break the software that he gave to the San Francisco Museum. And so part of the process is to disable the automatic update checks and to try to figure out how they could essentially keep these older iPads running moving forward. This is a TPM check that is not in my friend's software. These are checks that are in the software that is on the operating system software with the iPad. That if any damage occurs to that iPad, they might be able to get a replacement iPad, but it'll be running a new version of the operating system. And in order to install that old version, requires circumventing that TPM. And so
I think the question was whether there is a TPM at all, and in the case where there's no TPM, the operating system itself would not constitute a TPM. So I think we're all on the same page about that.
Okay, in this case, there's no TPM in that. I just wanted to be clear, there's no TPM in the software that was arguably being preserved, but you have to preserve the iPad and the operating system that is running on, to get at the point that was brought up earlier by Ms. Albert about dependencies that you have to track.
Right, so to preserve that, though, you'd be circumventing a TPM on a computer program, right?
I'm sorry, can you please repeat that?
You would be circumventing a TPM on a computer program.
On a computer program, but not on the...
It would cover within the scope of the exemption.
Okay, great.
Okay, Ms. Albert?
I just wanted to chime in to respond to your question about the 2006 exemption. So I think that the 2006 exemption, it sounds like, focused specifically on sort of like what wasn't meant, it was never meant to be a TPM, but it was, the software was meant to run on particular hardware. That was, what that sounded like they were not granting was that. And I think we're talking about, as Mr. Freeman said, and as Mr. Lowett said, something pretty different. And as Ms. Mold said, something pretty different, where we're actually talking about literal TPMs that are intended to function as TPMs, but are now, protecting works that are no longer commercially available.
Okay, so to that, so in 2006, there was 3 exemptions, or 3 parts of it. 2 granted, and then this one that we were talking about, which the office concluded was unnecessary. So it would also be helpful to understand what the difference, expansion, contraction, things that were not difference for the request now from 2003 or 2006. I don't necessarily mean to put you on the spot, you can answer it, but if someone else wanted to, that would be appreciated.
We would be happy to get back to you about that. I admit I have not, memorized the 2006 exemptions, which is perhaps my bad. But I'm happy to sort of come up with a more conclusive answer about how our exemption fits into that framework.
Maybe Mr. Williams might have memory or.
Yes, I recall what you're referring to, that where an operating system by itself is the reason that someone can't get to the work, that's not the fault of an access control. There were a few other points I wanted to touch on based on what's been said and Mr. Amer's question about, kind of how the various opponents are feeling about the narrowing that's been done. We really appreciate that the proponents here actually did make some significant efforts to redesign the proposal and to try to make it narrower and keep it a little bit closer to the statute and also what's been done in the past. We still have a number of concerns with it, even despite those attempts to narrow it, but we do appreciate that they really did make some real effort to narrow it. One of our primary concerns is that although they say that their intent is not to circumvent to access what they refer to as dependent materials, I don't think the drafting that they put in their reply comments achieves that. And I don't think that there's any reason to actually refer to dependent materials at all in any exemption if what you're trying to circumvent to gain access to is only a piece of software that then gives you lawful access to another type of work without circumvention of any additional TPM. So that's one of our primary concerns. And then a piece of that, which is very, very important, is that we do not believe that video games should be treated as part of the same class as what's being proposed here. We think that you should deal with those issues by considering the record that's being built on Class 8. And there's a number of reasons for that.
Can we just put a pin in the video games? Because I think we will get to that, but that's
Sure.
sort of moving on to the next topic, and I wonder if we can stick with the first point you raised
So-
now and get some responses perhaps.
Well, I would, and I'm going to talk about the program-dependent materials issue. I think that's really important. First, I did want to ask your views about the narrowing with respect to the obsolescence, for lack of a better word, issue. So, as you know, the original proposal was not limited to obsolete software. You raised objections. The proponents came back with a definition that defines. It doesn't use the word obsolete, but it's limited to computer programs which are no longer reasonably available in the commercial marketplace. So this is broader than 108C, for example, which is talking about formats that are no longer available. So I would be interested in your views as to whether this current proposal is acceptable to you.
Sure. So you put it exactly right. It is different than what's in the statute. It is an improvement over what was in the initial request. I'm still not content with the narrowing for a couple of reasons. One is we generally think that at a very high level, there's a number of ongoing processes related to defining what is lawful preservation, including Section 108 reform. We think this is a premature proposal, and trying to change what's in Section 108 now in an exemption kind of jumps the gun and could have a strange impact on that process in a way that I don't think would be helpful. So we do think sticking to what's in 108 is makes a lot more sense. The other issue is this question of what's commercially available, and I think they define it to mean that the publisher has to be actively marketing new copies in the marketplace, whereas the statute refers to if you can get new copies secondhand, that should be sufficient.
Are you looking at 108 for that?
Excuse me?
Are you pointing to 108?
Yes, 108 and the office's prior decisions.
Thank you. Mr. Zuck, could I go to you, because I believe your organization was initially opposed to the initial proposal, but now you are, am I correct about that, but now you're supporting the current language?
Yeah, we are, I think we still find the language of obsolescence appealing in some respects. And the reason is that in the software industry, TPMs might be used by multiple software packages. And so unfortunately, this is about the creation of tools for circumvention. And so if a particular piece of software is taken off the market and that's used, and it's one of 20 applications that are produced by a particular vendor, and that tool is then used for circumvention of the other 19 pieces of software, it seems like there's a substantial method for infringing use of the tool that gets created for circumvention just because one piece of software is no longer available on the market. So I mean, I think the language of obsolescence is something that we still find more appealing than just no longer sold.
I think the obsolescence is tied to no longer commercially available or no longer manufactured. Is that what you're picking up on from 108?
That's right, but I guess it's things like the floppy disk example, more so than simply that I'm no longer commercially able to buy new copies of a particular piece of software. Simply because TPMs are used across multiple programs, multiple pieces of software.
So
we're generally supportive. I want to be supportive of the intention here, right? But I guess creating tools for circumvention based on the obsolescence of a particular piece of software could still be the creation of tools for infringing activities on the remaining software that comes from the same vendor or uses the same commercially available TPM.
How is it necessarily different from any other regulatory exemption where you might be able to circumvent software for a particular purpose, such as cell phone unlocking or jailbreaking, and as long as it's for that purpose, you can do it, and you can use your tool for that, and otherwise you cannot?
I'm not a lawyer, so I may misstep here, but I guess it has to do with the substantial use, right? In other words, if it's the principal use for that tool is for a non-infringing purpose, it's different than if I use the hook of a particular software package going off the market to create a tool that then becomes available for people to use to unlock multiple other packages that then becomes not, the substantial use of that tool becomes infringing rather than non-infringing.
So just to sort of drill down on this, so I mean, the difference, as I understand, between your current proposal and 108C is that, so for example, if you have something on a CD, which is not an obsolete format, CD-ROM, or a DVD, but it's no longer produced anymore, it's not commercially available, you wouldn't be able to copy it under 108C for purposes of replacement, but under your proposal, you would. I guess the question is, what is the need for that sort of expansion? And I think related to that, would we be sort of breaking new legal ground by sort of ruling that type of activity is going to be categorically fair use?
Well, let me, I'm sure Mr. Lowe will be able to go into some of the more technical details about what it is that a library is going to specifically be needing to do. But let me just respond to that and also to Mr. Zuck. I mean, certainly with respect to the tools, I completely agree with Ms. Smith. I mean, that in theory is a problem with almost any exemption that, the person creates the tool for purpose A and conceivably could use it for purpose B. But if they were to do that, then they would be violating the anti-trafficking provision, and they would, if they were engaging in infringing activity, they would engage in infringement. And so, and again, given that this is an exemption that's aimed at sort of these cultural heritage institutions, I mean, the likelihood of, yes, there's always a possibility of someone misusing a tool, but I think the likelihood is very small. And then going to the issue of the specific issue that Mr. Amer's asking about, the software deteriorates. And so even if the format, it's not in an obsolete format, it's still, the problem is that the software is deteriorating, and software deteriorates, it turns out, far more quickly than we thought it was. I mean, these digital materials, you sort of have this image that somehow it's preserved forever, but that's not how it works. And so that's why, even if it's on a CD or if it's on some other medium, the medium might not be obsolete, but you still need to engage in the preservation activity.
But but it's not deteriorating for purposes of 108C necessarily, is it? I mean, because then you'd have to kind of say, well, everything deteriorates. I mean.
Well, right, no, but that to some extent is the problem with 108C, that it is too narrow, but I think,
I think he's looking for you to articulate the non-infringing basis then otherwise.
Well, then if it's not within 108C, it would have to be fair use.
So that's the question. So can you kind of help us in terms of, do you have a best case for kind of why this would be fair use?
Well, I would suggest that certainly, looking at the Hati Trust case and the Authors Guild versus Google case, that sort of the notion of creating, this digital database that no one sees the contents of, but then the act of sort of preserving it for other purposes is viewed as a fair use in those cases, and so much so that even in the TVI's case, Fox didn't even challenge the district court's holding that the creation of the database was non-infringing. They brought their challenge to the Second Circuit, and the reversal at the Second Circuit was all about the fact that you could access 10 minutes of it in a commercial context. And so it seems that if you look at that body of case law, and sort of what's going out on, happening in the field and so forth, is that the basic notion of making the preservation copy is fair use. The real question or the problem is, what kind of access do you have after the fact? But the sort of the behind the scenes copying, and whether it's Sega versus Accolade or Kelly versus all of these cases, the basic notion is the act of the copying or the preserving, that's fair use. And then where the rubber meets the road from a fair use perspective is what kind of access is provided to that content.
And is that what you're seeking in this exemption, which is almost to me it sounds like 108B, except it doesn't need to be unpublished. You can get access to make a preservation copy regardless of publication. This is what you've said for Hati Trust. No one sees it behind, but not necessarily to go further and use it as the replacement copy concept in 108C.
I would certainly envision it that way. And then to the extent that then what's being done with it after the fact, once it's preserved, then that becomes if what's being done is beyond the scope of what would be fair use, then that's an infringement. But the basic notion of the preservation should be permissible.
Thank you. Mix Albert?
Yeah, so I think I might disagree a little bit with my colleague, Mr. Band, or just have a different take on it, which is to say that I think that, it's important not to just think of it as we're making a copy to replace the one that, might someday no longer be readable on a floppy disk, but also that the way software is preserved is by making it runnable for people who need to access it for scholarly use and for, other purposes. And I think that's a core part of what SPN does and what's important to Stanford Libraries. So I apologize to Mr. Lowood for jumping on the point he was about to make. I'll also say with regards to specifically the fair use question, I think, in Authors Guild v. Google, they suggest that making copies of out-of-print books to save them is a significant public benefit. And I think in that, especially if we consider factor 4 of the effect on the market, one of the reasons we believe that once the software is no longer commercially available, it's fair use is because once the software is no longer being marketed, making preserving a copy and potentially making it available for library use is no longer affecting the market for that software.
But do you think you might be obscuring the difference between you have the right as a copyright owner to pull something out of market, sit on it, and then maybe reintroduce it, right? So a preservation copy might be one piece, which is where Hati Trust goes to, but to go the next step and say just because it's not commercially available, where do you impose the limits, as Mr. Van said, where's the rubber meets the road?
So I'll also let Mr. Lowood address this a little bit, but I think one important part that I've seen in SPN's work and additionally in the work of other preservationists is that even if work is a software work is later reissued or like another copy goes on the market, that preserving and allowing access to the original copy actually provides really significant cultural benefits because that's how we study software is by looking at multiple copies, right? So just because Word, 2016 is still on the market, the availability of accessing Word 2003 is incredibly important to cultural work, but I feel like I'm stepping on Mr. Lowood's potential options.
Mr. Lowood?
Okay, just a few just practical points, not legal points. First, just very quickly, the idea about the tools being used for one title and then being possibly applied to other titles where it might be infringing. We manage intellectual property issues for all kinds of materials. We would not use a tool in that way ever. If we would consider if a use of a tool would be infringing, we just wouldn't do it. At least that a library, I think most libraries would operate in that fashion. Secondly, about access and preservation, it doesn't really work to consider preservation in isolation. Preservation is part of a whole workflow, beginning with the decision to acquire, describe what's there, process what's there, develop the technology and the infrastructure for the long-term storage of the data, and then of course the thing that drives all of this, the mission of an institution like a library or museum is to provide research access at the end of that. So if, as I mentioned earlier, in some cases that research access will itself involve some sort of circumvention of a technological prevention measure because our disk image has not changed the presence of that in the software. So that's one thing we have to consider. But another thing just to keep in mind is that all of the resources that have to be expended to do those other activities that I described are depending on a result that is we will be able to provide research access to those materials. And so we just won't make the investment in doing all of those other things if the research access is not going to be part of what we can assure at the end of it. Last thing I'll mention is about the original version versus subsequent versions that might be reworked for sale and so on. For research use, the original version is just a different thing from a subsequent version that might be upgraded in various ways as typically done, high definition graphics and things like that, that are changes to the original in many ways. So I think we shouldn't really think of it as something like a reprint of a book or something that is an exact, perhaps an exact replica of the words that were in that book. It's actually a rather different thing from a historical perspective. There's less, no researcher would consider the current version of some game or piece of software, whatever it is, to be the equivalent of a historical version of that software. They're just completely different things. So there isn't really any confusion between those two versions that would be caused by preserving the original.
Thank you. So I'd like to go to Ms. Mould, and then just in the interest of time, I'd like to go to the opponents to get their view on the first, on the fair use question.
Okay, yeah, I'm sort of working backwards, so apologies for skipping around a little bit. Just to speak to what Mr. Lowood said, also regarding the sort of old and updated versions, in the case of Rhizome and many other like cultural heritage institutions that work specifically with digital files and their dependencies, it's not just sort of like different from a research perspective, it's very different functionally. So it may be that an artist comes to us with something that's a Flash piece, something that ends in a .flv file extension, and Adobe currently owns the rights to Flash software, but it sort of used to be Macromedia, and there were sort of 3 different versions of this sort of director authoring programs that were made. So even though they subsequently released these different versions, it may be that this modern file we have, even though the rights have been transferred many times and there's still maybe a functional equivalent of this that's legally and commercially available, is not going to be equivalent to what we actually need to open the file because of backwards compatibility reasons. So there are ways in which it's difficult to even see it as anything equivalent for functional reasons too, because it simply wouldn't even open these dependent files. And then the other thing I wanted to bring up was the idea of introducing sort of something that would limit it to, or sort of saying, okay, well, you could go online and buy a new copy from, secondhand, as long as it's a new copy, if that's available, even if it's not commercially available from the original vendor. And I think that would also be really tricky for us, because that also brings into question difficulties specifically because of TPM. So definitely there's a question of, if you're buying something not from the original vendor, even if it's commercially available, there's a possibility that if you were to say go on eBay and buy something that is supposedly new software, that the CD key that comes with it or something like that might not actually function, and therefore for preservation purposes it wouldn't be an appropriate copy for you. So it seems to really matter that it's available from the original vendor in this case, because secondhand copies might be inaccessible because of TPM. Oh, and the other thing was that we were discussing the 108C exemption, which museums are not currently covered under at all. So working at Rhizome, even if we were considered an extension of the new museum legally, such that I could say, okay, we're operating as a museum entity, that wouldn't actually cover us for a lot of this.
Thank you. Mr. Williams, so, what about the fair use argument, and particularly, the fourth factor? Is there really a substantial harm to the marketplace if we can agree that the software is no longer being made commercially available?
Sure, thanks. So your question was, would you be breaking new ground on fair use to grant what's being requested? And I think the answer is yes. The previous recommendations have said that there is no legal basis to assert that systematic archival activity of libraries and archives that is outside the scope of Section 108 would necessarily be covered by the fair use doctrine. And they've also emphasized that fair use involves a case-by-case analysis that requires application of the four mandatory factors to the particular facts of each particular use.
Do you think sorry to interrupt, do you think, is there an argument that the ground has sort of shifted since 2003, 2006 in light of Google Books, Hathi Trust?
Clearly those cases didn't exist at that time. However, if you were to read them as broadly as Mr. Band reads them, then the entire Section 108 reform process to create expansions to Section 108 would be completely pointless. I don't think those cases go as far as they're reading them. And I think that until Section 108 reform is resolved, we shouldn't be assuming that all of this other activity, which is largely undefined, what preservation means in the record, that it's all fair use. And you asked a specific question about market harm, and I think the point, and I know you don't want me to talk about video games specifically yet, but the point that was raised previously about the copyright owner's right to withdraw from the market is important, because with video games especially, there's an incentive to preserve them because they are often re-released, and so there can be market harm, as is discussed in the Class 8 filings.
What do you think about the phrase Mr. Lowid was using, was research access?
Right, so that was another point I wanted to raise, is that one thing that Jonathan said about the Google cases as well, the piece of it where it's preserved or copied but no one sees it, that under those cases is lawful in his read of them. But that's not, as I understand it, what's being proposed. There is going to be access provided, and so it's not that no one sees it. In the TV Eyes case, the fact that Fox didn't want to have to argue two separate issues when there was one so clearly in its favor in terms of providing access that was determined not to be fair use, the fact that they didn't argue the initial copying issue doesn't mean that they conceded that it's fair use or that it is a fair use. It's just there was an easier way to win the case. And so the research access, I would need to see, I guess, in order to weigh in on it, very specific language that defined exactly how stuff was going to be used after all of the copying is done.
Okay, but it's conceivable research access is different from, now I'm going to resell something on Amazon that maybe, right, research access could be more smaller than widespread access.
I would stipulate that research access is a narrower subset of activities than certainly redistributing things on Amazon, which should not be anything considered here at all. What research access means can the thing be copied and circulated around to other places? Is coming into a place and just playing video games all day research access? All of those are questions that are unanswered in the current record, and so I'm hesitant to endorse that concept.
What if access were limited to like on premises, which I think is the existing video game preservation exemption?
Well, I think that they have said that they would limit it to on-premises access in the reply comments. I did have a question about whether that meant that still additional copies could be made and provided to other libraries that would also provide on-premises access. Also, if you look at the record in Class 8, there's some real concerns about on-premises access still basically meaning that people can show up and play games all day, and that to us is an unauthorized public performance of the game, and you know, sometimes money is even changing hands, and so there are real market concerns and concerns about whether that would be lawful.
Thank you. Mr. Moore?
Just to, I guess, echo a couple of those points, so I think I'm going to be fairly brief. First of all, to the extent you're looking for consensus, I think I share the views of many of my colleagues over here in that, one, the concept of obsolescence is okay. We don't have a problem with that. I think what we're fighting about is the definition and as it's applied to access controls. Two, I think in terms of the fair use argument, I think there may be, I would certainly look at the cases differently, at the kind of at Google Books differently and analyze it differently if it was making a whole slew of digital preservation copies without the added functionality and benefits versus what actually happened in that case. I think if you had just a large-scale digital copying and no new so-called transformative functionality, you might get a different analysis. If you, that would be new law one way or the other. And the final thing I kind of wanted to get to is this echoes what I'm sure you've had this discussion in many other panels, including during the security discussion, but there's a causation requirement here in terms of that the prohibition has to be the cause of the issues, right? And so, I mean, I am sympathetic to the things that some of the specific examples that were mentioned. So, for example, if there's a server check and a specific access control and the server's not, that's an access control and the server's no longer there and the software has been acquired and it's subject to reasonable restrictions, that that's not the sort of thing we have a problem with.
So then would you, would you limit the class of eligible works to works that were originally, would you limit it to something similar to 108C, which is, works that were originally distributed on physical media? And if so, the other side has the argument, well, what if we have something on a CD, which is not obsolete anymore, or we have something that was originally downloaded, but there's not server support anymore, and so we can't access the program. Where do you come down on that?
Well, if they already, so if this is about preservation, so if it's something you already have a copy of, and you're copying indefinitely, whatever that problem is, that's not, I don't know that that's necessarily a preservation problem. I think sorry. All right, so let's take those examples one at a time, I guess is the easiest way, right? So in the first, let's start with the download example, because with my short-term memory, the way it is, that's the easiest one to start with. In that case, you don't really have a preservation problem because you can continue to back up a downloaded work almost, for quite some time, right? But you do have an obsolescence problem because the means of
the way you get into the program again. And that's, in that context, it's obsolete. That's how I look at it. In the context of a CD, I mean, you potentially have two kinds of problems. One is, all right, the media is deteriorating. Can you make a preservation copy? I know that most licenses for those media, a lot of licenses for that kind of media will permit you to do that. So that's not a bar. So the next question is, all right, in terms of can you then get access to what's on there if you image it, et cetera? And again, I think the question comes back to obsolescence and not so much the question of preserving it. Does that make sense?
Thank you. Let's go to Mix Albert.
Yeah, so I just think that I want to echo what Mr. Lowood said earlier, that it doesn't make I think the distinction that the opponents are drawing between preservation and access is not one that we actually see from practitioners in the field, that ensuring access to works is the purpose of preservation. Keeping a copy that no one can access and indefinitely, transferring it across formats is not consistent with the best practices in this field at all. And so I think that, the problems that we suggested of the problems with Section 108's obsolescence requirements are the problems that keep software from being preserved and keep software from being accessible, even in cases where folks own a copy. And I want to sort of just note that I think lots of, especially in the context of this proceeding, lots of folks have recognized that there are lots of difficulties with Section 108, and I worry that I would strongly encourage the office to sort of cast allow all non-infringing use under the exemption and not just limit it to the sort of the uses conceptualized under 108, because as we saw in the case of the cases we've already cited that have happened since 2006, there's a wide variety of uses that are considered non-infringing that hadn't been conceptualized when these exemptions were previously considered, and that I think as we talked about in our reply, the leeway that fair use allows for copies that might be made slightly outside of the the very narrow constraints of things like 108C is incredibly important to the sort of actual practices of preservation. And I think that that's a key part of what's important to us and what's important to sort of preservationists more generally.
Thank you. So I'm going to go to Mr. Band and then Ms. Moulds, and then we're going to move to the question of program-dependent materials. So these will be the last two comments on this topic, unless my colleagues have questions.
So first, to some extent in response to Mr. Williams' suggestion that we wait until the 108 process is done, well, we might be waiting 20 or 30 years, and in which case, another generations of software and software-dependent material will not get preserved properly. So waiting for 108 is, I don't think, the best approach.
I think the Copyright Office, we are eager to continue discussing documents, so.
So that's number one. Number two, just to make clear my point with respect to preservation versus access. Obviously, the goal is access, but there are different kinds of access, and certainly your suggestion of research access seems to me to be highly likely to be comfortably within the zone of fair use. Other kinds of access, maybe not, such as just putting it out on the open internet for anyone to access. I mean, maybe under certain circumstances that could be fair use, but that's less likely to be. But also depends on what the software is. Restricting it to on the premises, as in 108, I think is perhaps too limiting, and maybe that was, and certainly beyond the scope, I think, of what a court now would consider to be fair use. I would certainly think that in the case of Stanford, you would want it not just at the university, at the library, but it's probably for authorized users on campus, conceivably authorized users off campus.
But that's not what you're asking. Sorry to interrupt. You're not asking for that here, right? I mean, I thought your proposal's limited to provided that the computer program is not distributed or made available to the public outside of the premises of the eligible.
Well, and at that point, it could be that the libraries disagree with the software preservation network on that specific point. I mean, that we think that it should be, that conceivably off-premises in appropriate circumstances should be, would be appropriate. And that's why, again, we would think something that doesn't have the on-the-premises limitation is reasonable. But I think the basic point is that it should be simple, flexible, and again, especially if it's limited to research uses, then I don't think you need to necessarily limit it to on the premises.
Ms. Moulds?
Yeah, I just wanted to speak quickly to this, the first example of sort of downloaded software not necessarily having a preservation problem. I would argue that sort of somewhere in between what Mr. Lowood says about that and sort of my stance on it, like, I don't know, it's a little bit difficult to articulate, but there are cases where I want to know that the software that I have downloaded is intact, and one of the places where that sort of falls apart is proprietary compression software. So like the zip format, which thankfully right now, there are lots of functional options for opening zip formatted software if you've compressed something into a zip. But when you run into older stuff like the stuff at Expander kind of file compression and these sort of obsolete file compression algorithms that you may need a proprietary piece of software to open, but maybe these proprietary pieces of software to zip and unzip this software have fallen out of commercial usage. That's a case where if I have something that's in that format, that's been compressed in that format, and I look at that browser download, I don't really know whether the file that's inside that compressed format is intact. And so it's difficult for me to say as a preservationist, yes, I definitely have a preserved copy of this file when I can't even open it in terms of being able to uncompress it.
Thank you. So I'd like to turn now to, just in the interest of time, to the issue that was raised about program-dependent material. So the proposal would allow circumvention for the purpose of preserving a computer program and or a computer program-dependent material. And that is defined as a computer program-dependent material refers to a digital file where accessibility requires a computer program. So I think the first question that I think was raised by Mr. Williams is, why do we need to include that in this definition? I mean, as I understand it, you're not talking about circumventing TPMs on computer program-dependent materials. This is a situation where, if you have an old, if you have an old word processing program, you're also interested in preserving digital files, literary works, other types of works that were written on that format. But why do we need to include that? I mean, that can either be infringing or not. Why do we need to go that far in this exemption? McSalver.
Sure. So the reason we included that is to make clear that this exemption covers use cases involving like program-dependent materials, which is actually a significant percentage of the use cases that are important to software preservationists, right? It's not necessary, there may be situations in which preserving the software is the sort of like activity that one is engaged in, but as we talked about, I think in the reply brief with the sort of examples regarding AutoCAD, right? Often there are actual software, files or files that require a particular version of software. And so the reason it's in here is to make clear to folks who might use the exemption that this exemption covers that activity. As we have talked about, there's a really significant chilling effects from 1201, but also sort of a very conservative bent to many practitioners of software preservation, especially in large institutions. And our goal here was to make very clear that if you're circumventing the TPM for the purposes of preserving the computer-dependent material, not just the computer program, that's still a thing covered by the exemption.
Thank you. But so as it's currently defined, it's pretty broad. I mean, and it's not, the computer program-dependent material is not limited to, obsolete formats or program-dependent materials that are no longer commercially available. It sounds like that's kind of the thrust of what you're trying to preserve. I mean, would it be acceptable to you to have a limitation where, if we were to include program-dependent materials, that we had language to the effect of, where those materials are accessible only by interoperating with the program that you've gotten access to as a result of the exemption?
So just regarding narrowing that, I appreciate that there's some circularity also to the definition. We actually thought about that particular issue of whether we thought narrowing it was possible, and I think one of the reasons we leaned against sort of requiring you can only circumvent a TPM on software in order to access that computer-dependent material if it requires that particular piece of software is because often the actual process of determining that would be incredibly difficult, right, to determine whether there were alternative pieces of software that might access those kinds of files. And because the reality of software preservation is nobody circumvents things they don't have to, the process of circumvention, even under the exemption, is sufficiently complicated and not, to put it mildly, not fun. So that the reality is that if there's a commercially available alternative piece of software that reads those files in the way they're originally intended to be read, that's going to be the alternative that the library, archive, the cultural heritage institution would pick.
Let me ask a question as well, sorry. Would that also be if the newer versions of that software were backward compatible, or they could read some of that, and where do you run into problems with that? For example, with AutoCAD, you have many versions that have come out. You may have made a design in AutoCAD in 95 or whatever, and then 2004 version, it only reads parts of it, but so you have to go back until you find a version that would read. Does that make sense? And is that something that you do as part of that analysis to figure out which one will open it? Or
Yeah, exactly. So part of the reason we wrote that in is because of exactly that problem, which is that even software that is theoretically backwards compatible doesn't necessarily produce all of the same information as software that, as the original version of the software that the file was written in. And so the goal is that if you wanted to access that AutoCAD 95 file, you may, in order to view the file in the way it was originally intended to be viewed, need to access it in AutoCAD 95. And I see that Ms. Mold has her placard up, so she can probably tell you more about it than I can.
Please.
One example I can give of this is the GIF standard, like the animated GIF. That is one thing where you can have a GIF that was made in 1999 and a modern browser will still open that GIF, but the way that browsers interpret those GIFs is completely different from browser to browser, and especially around 1999 or 2000, there was a lot of sort of variation in the way that format was interpreted because the sort of World Wide Web Consortium standards weren't completely solidified around the file format. So we have cases where we have artists who bring us works that have GIFs in them, and we really end up needing to display them in some particular browser, because otherwise it'll be like cycling through something super fast, or it'll be way slower than it was intended because they had made it for this particular browser and made it to appear in a particular browser in a certain way. So even though if you were to go to something like the pronom file type database, it would tell you, yes, absolutely, you can open a GIF in Chrome 60, your current version of Chrome on your computer. Yes, that's true, but it might not interpret it in the way that the artist intended, and to us as a cultural heritage institution, that's really important.
Thank you. Mr. Williams?
Thank you. Yes, we were very relieved to see in the reply that the end goal is apparently not to circumvent any access control on what's being referred to as dependent materials. We don't support the adoption of the class of works, but that was clearly a significant improvement. But as you were saying, and as I was saying earlier, I do think that essentially means that if you were inclined to do anything in this area, there's no reason to reference the dependent materials and accessing them. If you were able to define a category of activities that could be described as preservation that you were confident were all non-infringing, and if you were to say that circumventing an access control for the purpose of gaining access solely to a piece of software for the purpose of preservation, those defined activities, there's no reason to reference the dependent materials if there's no circumvention required to get at those materials. So that would be, I think, our position on that. If I could just respond quickly to one thing that was said about 108 reform, if you'll indulge me. Jonathan said, well, if you're going to wait for that to get completed, it could be 20 or 30 years. Well, part of the reason for that might be that Jonathan's clients are expressing opposition to it passing. So to me, it would be a little perverse to say, you should give us an exemption because we're holding up the very process that might get us some relief that is balanced in a way that government can get on board with. I can't speak on behalf of each of my separate association clients as to their individual positions on every aspect of what's in the discussion document, but they do publicly support preservation efforts of legitimate nature, and I think for them it's more about defining what those things are. So I just found that to be a little bit of a misleading argument.
Some cards were up, but they've gone down. Let's go to Ms. Meyerson.
I just wanted to follow up with Mix Albert's comment earlier about the need to clarify for cultural heritage practitioners that this is, if it were granted an exemption that they could use to preserve software-dependent works. I think this is crucial in representing the organizations that we do. I just want to point to a Mellon-funded report that was written in 2015 by David Rosenthal, who's no longer at Stanford University, but worked for LOCKSS, which is a distributed digital preservation dark archive network, a consortial entity, that it's clear that institutions will not build collections of preserved system images and software at the scale needed to preserve cultural heritage unless the legal basis for doing so is clarified.
Thank you. I wanted to follow up, and Mr. Brand, you can maybe incorporate this into your answer. I mean, I guess one concern is if we don't limit the program-dependent materials to commercially unavailable works, is that would that sort of be, suggest that the Copyright Office is kind of making a determination about whether, that preserving, copying for preservation purposes, works that are still commercially available in some cases would be a fair use. I mean, that certainly is far beyond 108. So I think that would be a concern for us to the extent that it is necessary to address program-dependent materials.
Well, let me first address the necessity to address the program-dependent materials, and then I'll get to your specific question. So it seems that you need to include program-dependent materials because the reason you're circumventing is not to get access to the software. And so in every other case, right, in every exemption, you're saying you're allowed to, you have to define a class of works for which you're allowed to circumvent. But the class of works, we're circumventing the protection on software, but not for the purpose of getting to that software. So I think it would need to be clarified, and otherwise people, unless it's clear that, it's worded in such a way to make it clear that that it's not restricted to just, you're not trying to just preserve the software, but you're able to get to the Adobe file itself, then there'll be confusion. So maybe there is some way to draft it, and maybe this is really a drafting issue, but the key is to make sure that in whatever you do, that it is unambiguous that it's the Adobe file. If you're trying to, preserve the Adobe file, that you should have a way of doing that, even though, you're not interested in preserving the Acrobat,
So are you agreeing with Mr. Amer that there needs to be a reason to preserve the Adobe file?
So, well, first of all, I mean, I think it needs to be clear that there's that the software-dependent material, that it's not limited to preserving software, but as well as the stuff that runs on that software, the files that are dependent on that software. And again, maybe it's a drafting issue, but
That all files that run on the software, or files that are no longer commercially reasonably available or in need of preservation?
well, I guess part of the problem is like you don't, I mean, there's, I would think that then there's so many different kinds of files. So, it would see, I think you would want to be able to, at least for preservation purposes, do, sort of like any preservation that would be likely to be a fair use. And so it could very well be that you would be making a determination of fair use maybe broader than you want if you start saying, okay, well, you can do it for this and not for that. And just say, okay, you're able to, all we're saying is you're able to do the circumvention. And then what you do with that circumvention, if you cross the line and do again, it's, I imagine no one's going to sue you with the preservation, but if you somehow preserve and then provide access to some file that is somehow somewhere on the market and in a way that person feels is not, goes beyond fair use, that the institution will get sued and it'll be litigated. But that goes beyond of what you need to define here. Here you just need to say you can engage in the circumvention, and then it's up to the caveat emptor or whatever the Latin equivalent would be. I mean, it's if the institution goes beyond what's prudent, then it's it's up, they get sued.
So you're saying, you need clarity, you need to include program-dependent materials because you need clarity that where your ultimate goal is to preserve, those dependent materials that need the underlying program in order to run. So if we were to do that, we're sort of, in order to do that, I think we need to sort of, I think, make a determination that, well, that activity itself, that preservation of the dependent materials is going to be non-infringing. I mean, we can't, sort of, I don't think there's any way for us to say, well, you can do it for purposes of preserving, program-dependent materials if we're not fairly confident that that activity is going to be non-infringing. But how can we have that confidence if the class of those materials includes things that are still commercially available in some cases, or that don't require maybe the old Commodore 64 software to run? Maybe you can run. I mean, I don't know how far-fetched that example is, but I mean, if the need is based on the idea that you have to run this underlying operating system in order to run the files, then why can't the class of dependent materials be limited to those kinds of files?
I guess the short answer is I don't know enough about the technology to say that, whether it's possible that those files could only run on that format, and whether that, by wording it that way, you could cause some unintended consequences and unreasonably limit the access that you might otherwise have. I mean, part of it is, it could be that this is the file that's in your possession, right? I mean, someone donates some files to the museum, that's what they have. They don't have something else. I mean, so, and that's, so they have to work with what they have. The fact that someone else somewhere might have some other file, or that file in another format, doesn't really help them. But I guess, and then I'll yield the floor to Ms. Albert. The other point is again, the framework of the exemption says that all of these, you can only make any of these uses to the extent that they're that the ultimate use is non-infringing, right? That's that's always there. And so to the extent that what you're doing ultimately is not, if it's infringing, then you're infringing. And so you are not making a determination by virtue of giving an exemption that allows step one. You're not deciding, what step 3 is necessarily infringing or not infringing. I mean, it could be what someone ultimately does with it could be infringing, or it could be not infringing. And if it's infringing, then they get sued.
Thank you. Ms. Albert?
Yeah, so I want to push back pretty strongly on the idea of focusing on commercial availability for these files, because I think that maybe it stems from sort of I do think the category is broad, but the ways in which this kind of thing usually comes up is that the kinds of files we're talking about are already present in library collections. This is like, the things like we mentioned in our reply have to do with like AutoCAD files that are being used to like access historical information about architecture, or like data sets that researchers need to replicate. Like, this is not the sort of thing where commercial, like, I don't, if we think that we have problems determining commercial availability for the software, that's an entirely separate, I can't imagine even how we would think about it from the program-dependent materials. And in terms of the sort of fair use analysis, I think what I would say is that my understanding is that, that has to do with the work that the TPM is on, and that you're looking at that as the determining whether the circumvention is appropriate. I think that, the ultimate potential purposes that it might be used for down the line I don't think that necessarily requires the Copyright Office to make a determination about the use of those works.
Thank you. Mr. Troncoso?
So it seems that really what we're talking about for the software-dependent materials is we're talking about materials that are on obsolete formats. I realize that that's a term of art from 108C, and that in 108C it's sort of talking about physical formats. But I think if you look back to the 2003 Copyright Office recommendations, they interpret it as also including any system necessary to render perceptible a work stored in that format. And so I think if we look at this through that frame, and if you make clear in your recommendation this time that this type of activity should be encompassed by the rule, I think using 108C as the template for how we look at these things can work, and I think it can alleviate probably a lot of the concerns that, on the proponent side as well. Or I'm sorry, the opponent side. But so I want to throw that out there as like almost as a discussion point for the group. You may have questions too, but.
Yes, Mr. Lowe.
Yeah, this is just an echo of what Ms. Albert just said. From a library perspective, I understand that this discussion is about the red flag being commercially available dependent materials that circumventing TPM on obsolete software would somehow open up access to. That is a complete non-issue from a library perspective. I don't know of any collection that we have that would apply to. The reverse is much more likely, that currently available commercial software that renders obsolete software happens a lot, but that something would be unlocked, some dependent software would be unlocked that is commercially available by circumventing for the obsolete platform. That's just, I would love to hear an example of any kind of collection like that. I just don't know of any.
So I'm going to go to Mr. Williams, and then we're going to move on to video games.
Okay, that was actually going to be my question. Is I see them more as a dependent material than as similar to the other types of software that is being discussed. So I was going to ask, should I talk about video games as the dependent material, or so I'll just lead in from there. As I was just saying, really what seems to be at issue is pieces of software that are not entirely functional, but essentially provide the function of getting access to other works and then getting that access doesn't require some additional act of circumvention. Video games as software are also audiovisual works. They're also expressive works, and they are more similar to these other dependent materials than they are to those more functional pieces of software that you might need to get to in order to access the dependent materials. So they're distinct, and as we discussed before, they're often re-released. In terms of research purposes, they're distinct from, an old piece of operating system software, because you're not going to get a line around the block to come look at how, an old browser worked. That's likely to be something only scholars are interested in. But if you've got access to a bunch of video games, you could have a pretty high level of demand for that. They're just a distinct set of works. And the other concerns that are raised by them are that sometimes the piece of software that maybe would get you to the video game is the type of firmware on a console that you have repeatedly concluded hacking can cause all kinds of harm, and as is at issue in Class 8, there's stuff stored on remote servers that might have to be hacked in order to get to it that could cause all kinds of problems and result in infringement of unpublished works. So I just want to emphasize strongly that we feel like video games should not be a part of this class. That's a huge piece of our overall opposition to it. And so if you have any questions about that, I'd be happy to answer them.
Thank you. So just to clarify, so would video games be included in the class, or are those just program-dependent materials?
It's our position that video games would be included in the class.
Even though, as Mr. Williams said, I mean, they're not just computer programs, they're also audiovisual work. So that expands the
I mean, all computer programs. I think Mr. Williams seems to think that there's a much clearer line between the types of audiovisual works that video games are and computer programs that otherwise contain parts interface items that might be expressive, right? I think that I don't think that line is as clear as Mr. Williams seems to suggest it is, and I think that as we said in our reply, all of the same arguments we made in our original petition cover video games, and I think that I admit I find it really surprising to consider them in the realm of sort of program-dependent materials, and I saw Mr. Lowett's card go up, so I can let him address that.
The first thing I want to say is I would love to have lines of people waiting to get into the library to use something. We've provided access to the games in our media center probably for at least 15 years now, and the use has been entirely either research use or instructional use, for courses. Nobody's ever come to the library, as far as I know, for any kind of recreational use. Also, I mentioned, because performance was mentioned earlier, performance rights are a whole different thing, and we know all about that, and nothing about performance rights is suggested by any of this. Games is a class of software. I might mention that I'm also a historian, and mostly what I've been writing about the last 15 or 20 years has been history of video game technology. It's something that I've worked on quite a bit. Just to echo again what Mix Albert said, all forms of software do have audiovisual components to them. There's nothing particularly unique about the fact that games render graphics and music. For example, let's look at educational software as another category, same sort of thing. Ebooks, many classes of multimedia software that are not game software render imagery and include audio on them. They're multimedia works. That's very typical for software to be able to do that. One of the great things about software is that it can do so many things, and games do indeed take advantage of many of the capabilities of software. One of the reasons that games are so difficult to preserve is that they involve all of these different components. The performative aspect of games, the fact that somebody is operating the game, could also be compared to reading a book or listening to music. That those are activities that, in our context of the library, are conducted as research activities. People do play games or listen to music or read books for recreation, but they also do it for research. It's something that certain areas of scholarship or instruction require. So I don't think it's very difficult for me to think of any clean distinction between games and software that would hold water, that would be a useful distinction that could be clearly applied in this case.
Now, the opponents argue that, that video games are already covered by Class 8, and I understand your response to be that Class 8 is limited to server-based games. Could you elaborate sort of on the need, why, is it problematic to have sort of overlapping preservation video game exceptions?
Sure. So I'm pretty familiar with Class 8, and what I'll say about it is that I think it covers a very narrow slice of the types of TPMs that apply to video games. It covers like server-based authentication mechanisms where an outside server is necessary. I think that the record in Class 8, was originally developed in response to that particular sort of prompt and that particular subcategory. And that, a lot of the concerns that the Entertainment Software Association has expressed regarding that category have to do with the very particular aspects of server authentication, local play, multiplayer play, and now MMOs. The types of works that we're talking about in the context of this exemption, we're literally talking about like video games that were distributed on floppy disks for like the Amiga or the Commodore 64. And the sort of mechanisms of copy protection are akin to all other software. So what we've suggested is that we understand that the Copyright Office has a very particular record and has spent a lot of time determining what the exact contours of an exception that apply to server authentication should be. We think if it's a server-based TPM on a video game, then I think that exemption should apply. And in other cases, I think that the clear overlap that Mr. Lowe was talking about between video games and software generally suggests that the kinds of preservation uses we're talking about and the considerations here would apply. And we specifically mentioned I believe Battle Droids and Darkside in the reply, but those are the kinds of works that we're looking at, ones that are no longer commercially available, not dependent on a server authentication mechanism.
Thank you. I'm going to go to Mr. Freeman and then Ms. Moulds, and then we'll give Mr. Williams and the opponents a chance to respond about video games.
So another hat that I wear is I co-facilitate art courses at the University of California, Santa Barbara. And many of our students do essentially a lot of sometimes conceptual or performance-based art. And sometimes the boundary between something that is a game and something that is an art piece is something that is actually difficult to even draw. It's not just a matter of as Mr. Lowe was saying, it's like how can you separate a computer program from a video game, but how can you separate a multimedia work or from a game sometimes? How can you separate? Actually, the example that I brought up earlier of my friend's work that got put into the San Francisco Museum of Modern Art catalog. That's something where he himself does not think that's a game, but many of the people who have interacted with it do feel that it is a game. It is one of these performative, interactive artworks. And then I also will point out that there's a museum, it was mentioned of Mr. Lowood in his collection, but there's a museum, Living Computers Museum, which, to react to some of the earlier comments, actually they really are about just letting you understand and experience what computers were like back 20, 30 years ago. And so sometimes, I don't know if you're going to line around the block looking for what a web browser used to be like, but you are going to see people who are just interested in what a word processor was like 30 years ago. And right now they have an exhibit on what video game arcade machines were like in the 80s. It's a kind of an experience that people can no longer have. These are cabinets and games that are no longer commercially available. And that's the kind of thing where if you were to do that with machines and that are available today, in another 30 years from now, they would be protected by some kind of TPM that would make being able to repair and maintain them in a museum setting impossible.
Thank you, Ms. Moulds.
I just wanted to start by echoing the sentiment that determining legally what constitutes a video game.
I understand. We're not going to
okay.
solve that ontological question today. We're taking on a lot, so let's just
Excellent.
move on to what we can do for copyright law.
Another thing I wanted to say was
it's been a long week.
I would consider, in some cases, video games to be dependent software because we have, even at Rhizome, specifically seen cases where artistic works are game modifications, they're mods. So we had one work called Velvet Strike, and part of that work was a performative act where there are videos of people playing Counter-Strike in a very particular manner. And then there are other parts of that work that are mods that people were encouraged to download and install themselves into their own copies of Counter-Strike. And so in this case, I think that potentially those mods could still function with commercially available copies of Counter-Strike, and I'm not able to think of a better example of this where the software is already obsolete, but in the near future, that software could become obsolete if Valve were to pull it from Steam or whatever it is. And I think very much there are pieces of art that are dependent on video games in terms of access.
So, Mr. Williams, I mean, what about this, Mr. Lowood's point about, it being sort of far-fetched that people are going to be lined up around the block to go to a library to play a video game?
Yeah, I mean, lined up around the block was kind of casual language for a concept that I think still holds true, that there's higher level demand for classic video games than there is for most pieces of classic functional software. And I think the evidence that ESA put in on Class 8 is demonstrative of that. I wanted to clarify something because, I'm here representing specific organizations, one of which is ESA. So our interest is focused on video games. I tried to say earlier, and I'll maybe say it more clearly now, I'm not saying that there's no other types of software that are expressive and that everything else should be in bounds of an exemption. That's not at all what I'm saying, and I don't think the record's been built to establish that. It's just that the gentlemen to my left are far more appropriate to speak to those issues because of the interest they represent. I'm focused on video games because ESA is one of my clients, and I think that the record on this class with respect to video games is very, 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 very sparse. There's a couple of examples that are discussed, and I think what is said is that they believe that they would have to circumvent copy protection measures in order to engage in the conduct at issue. A copy control, of course, is not an access control necessarily, and there's really nothing done to beef up the record and establish that even in those two examples that access controls had to be circumvented. And with respect to video games, there have been previous records where far more evidence was put into the record, very careful thinking was done, the exemptions were denied, or a specific exemption that we're now relitigating with Class 8 to some degree was granted. That's the kind of record I think you have to build to justify an exemption, and the fact that their proposal is so broad that it's difficult for them to put evidence in the record on every single piece of what they're trying to get at is not a justification for granting the class. If ultimately you decide that you can define a set of activity that is you believe to be sufficiently non-infringing and that applies to other types of software that aren't video games, then that's not what I'm here to debate. I think that would be, based on this record, not the right decision, but I'm here to speak on behalf of the video game industry, and if other pieces of the software sector that also create expressive software don't have as big a problem with it, then I can't address their market issues. But I do think for video games, there's just not a record here to justify it.
Thank you. Max Albert?
So I just want to respond to that briefly. I think, I'll start with a very more specific point, which is about the copy controls section. So as we said in our reply, and as Mr. Lowood actually, I think, said earlier, that the use of the term copy control can be is often colloquial, but they often basically function as access controls. So I just think that that's maybe not the correct characterization. And I mean, I think just with regards to the sort of burden, I think that we think that video games are like other forms of software. That's why we chose to write the class the way we did, and to include video game examples, and we did, provide more detail on those video game examples in our reply. And I think that meets the burden of showing that there are adverse effects of the prohibition on that particular part of the class. So, I understand that the ESA has strong feelings about video games, as do I. But I think that given they provided, no evidence why this exemption, they sort of refer to the Class 8 exemption, which is, the types of evidence that are coming up there are frankly entirely different than the kinds of sort of uses that we're talking about here.
Thank you. Mr. Lowood, let's go to you, and then we'll move to the next topic.
Okay, I'll make it quick. I just wanted to say about sort of the popularity of games and such. In the cases where there are older versions of games, and that's what we're talking about here, versus newer versions that have been changed in some way, there's actually a fair amount of research already, both in the museum world and in the preservation world, that contemporary players today, kids today, basically much prefer to play the more recent versions of games. They're not confused at all. Their interest is actually quite low in the older historical versions. Could refer you to the Seeing Double exhibit that was at the Guggenheim some years ago. That was one example where that was shown. And so that really, again, there isn't that much confusion between these older versions on obsolete platforms that we're talking about from a preservation point of view and the sort of contemporary play interests of people today.
Thank you. Moving to a new topic, I wanted to ask about the term other cultural heritage institutions, which was a source of some debate. So the class of institutions eligible for this proposed exemption would include library, archive, museum, or other cultural heritage institution. The concern that was raised by the opponents is that other cultural heritage institution is sort of an ambiguous, amorphous term. And to sort of drill down on this, I wonder, if you had considered, again, plugging the 108 discussion document from our office, which in its proposed changes to Section 108 would include some additional criteria. It would extend the eligibility for 108 to include museums, but it had, in addition to the current eligibility requirements, 4 additional requirements: public service mission, trained staff, lawfully acquired materials, and reasonable digital security measures. I wonder if you had considered including those criteria.
Sure. So I believe we cite the 108 discussion document in our reply, saying that we believe the other cultural heritage institutions should share those proposed conditions. And Ms. Moltz can speak to, with particularity, why we think that that's important. But I think it has to do with the specifics of how software preservation works. So I think we would be comfortable with those conditions.
Ms. Moltz?
Yeah, I think that's generally accurate. And Rhizome was originally founded as a sort of an artist group of artists sort of discussing, like a collective, and sort of the idea of preservation and starting an archive came up out of a desire to preserve the works that were being created in this community specifically. And so we are affiliated with the New Museum, but we haven't always been. We're independent in a lot of ways, legally and as an institution, from the New Museum. And so I think technically, I'm not 100% clear whether adding a museum to the language of 108 would actually include us. And I'm also hesitant because in my mind, I feel like even before we were technically part of the New Museum or affiliated with the New Museum, as a cultural heritage institution that was a collective of artists interested in preserving their own work as they were threatened with obsolescence, that should be something that should be considered within the bounds of this exemption.
So before you were affiliated with the New Museum, did you fit the other criteria in the 108 discussion document?
I can't say because I didn't work at Rhizome, but I suspect that we would have.
So the first criteria in the 108 discussion document talks about public service missions. So would it be acceptable to you to limit this to exclude for-profit institutions? Yes.
So I mean, I think that I mean, maybe this is me overlayering this, but I would read public service mission as not necessarily totally aligned with like the for-profit, nonprofit distinction. And I think that there are some organizations that operate technically as for-profits that I believe have the public service mission. So I'd be comfortable with the public service mission language, but I think I wouldn't necessarily want to rest the distinction on like the, you know, how they incorporate it or whether they got tax status through the IRS.
Ms. Molds?
Yeah, similarly, I think when Rhizome did form as an artist collective, it first incorporated and then later had different articles of incorporation as a nonprofit. And I think that generally another case that might come into concern here is the idea of galleries, some of which operate for-profit, some of which operate not-for-profit, and also even just like smaller collections or individual collections. We have this issue where if someone wanted to acquire a work that had a dependency on obsolete software, so if a nonprofit gallery was showing this artist's work and then an individual said, I want to acquire this software, or I want to acquire this art, and it has this dependency, and then maybe they acquire that software and the motherboard on the computer dies, or something happens where the obsolete dependency needs to have its CD key re-entered. Like, are their hands tied because because this piece has been purchased by an individual collector and it's no longer part of a cultural heritage institution? Are they then unable to circumvent the TPM on this obsolete software format because it's entered the collection of a private collector who's not associated with one of these cultural heritage institutions anymore? That's a question that I have. And I think that's something that affects being able to sell or see these digital works as commercially viable at all, because even if all of this software is currently commercially available, it's difficult to convince a collector that all of these dependencies will exist in the future, even if they have access to the artist's files indefinitely.
McSalbert?
Yeah, I just, Ms. Meyerson suggested I add, which I think is relevant. So often there are, organizations like design firms or architectural firms that have archives that may meet most of these criteria, but aren't necessarily operating as nonprofits, so.
Do you have examples of that in the record where they need to circumvent and they don't own the copyrighted work?
I don't have examples of that off the top of my head, but Ms. Meyerson.
Ms. Smith, can you clarify that question? I don't think I heard what you said.
I'm trying to figure out where you've demonstrated the need for that of design firms or architectural firms where they need to circumvent something to access a work that maybe they don't, and when there's an issue that they would not have had the permissions to engage in the circumvention.
I can actually answer that question. On page 4 of the reply, we cite Eliza Leventhal, who's a librarian and archivist at a design firm, who talked about the specific issues related to AutoCAD and file preservation.
Thank you. Did you have a follow-up?
Yeah, so she works at a private design firm. Is that right? Like, I mean, in no way, how is that a cultural heritage institution, a library or museum, if there's nothing open to the public? That just sounds like a private institution.
That's true. Their archives are not open to the public, but these members of our community do participate in all of the same digital curation and preservation activities, which is why I raised that. So in terms of accessing their own internal work. But yeah, you're right. It does not meet that criteria.
Would you be comfortable incorporating that criteria, those criteria into the exemption language?
Yes.
I just would like to invite the opponents, to address this issue, because you had raised concerns about this other cultural heritage institutions language. Would the incorporation of the 108 study factors do anything to allay your concerns?
Yes, definitely. Would be comfortable.
That would improve things.
Okay, thank you.
Is your placard up? Okay. All right, I think we are on a roll. We're going to end this session also 13 minutes early. So we had scheduled at 4:30 audience participation, and if it's something that you may be interested in, if you could please come up, we may actually be able to, I think, begin that a little bit earlier than 4:30, so we can all get out of here a little bit earlier too. But thank you very much.
Thank you.
This has been a presentation of the Library of Congress. Visit us at loc.gov.